good afternoon. Good afternoon. So, how is everyone doing today?
Afternoon, sir.
Hi, good afternoon. Doing
Thank
pretty all right,
you.
sir. How about
Good
you?
afternoon.
Um,
So,
Good, good. Well, I'm hanging in there. Fridays are weird for me because my teaching schedule is spaced out to the point that it's hard for me to do anything around it. So I sort of find myself with some times kind of at loose ends on Fridays. So how are you guys feeling? Right? How are you feeling about things like getting ready for the midterm in this class? How do you feel about the midterms in your other classes?
Sir, I'm not ready at all.
sir, wait. I have
I
a
have so many
question.
things to do. I don't know where to start.
Well, uh, what can we do? What can we do to help you feel better prepared, or to give you some tools to help you prepare?
My first thing is getting a 4,000 paper really started.
Which course is
That
that
seems to
for?
be, that is constitutional law.
Hmm.
I started it, but there's a block there, and
Is
that seems to be holding up everything.
is Professor Ventos teaching that?
Yes.
Well, that's I tutor for Professor Ventos in administrative law, and I mean it's bold that
Yeah.
midterm assessment. I can't imagine being terribly uh, engaged with reading 4,000 word essays from 120 students in one class, much less two, because he's doing something similar in admin. Um, so uh,
It's
that's
not
happening.
hard, you see, but it's doing that along with the other things, you feel bogged down.
Yeah, yeah, and it's. I mean, that's a you know I can crank out 4,000 words in a couple of hours, right? Especially if it's a topic that I already know.
Yeah.
Um, but uh, for students, for learners, right, that's a lot more. That's a lot to ask. Which is not to say that you can't do it. That I don't have faith that you all will be just fine.
Yeah.
Just I understand how it can feel overwhelming. So
Yeah.
um, hmm. Let's see if I can throw a couple of things your way that might help you sort of string the words together. Um, so let me see. We have, here we go. So one of the things that I always have problems with in writing papers is going from the blank sheet of paper to the um, forgive me for calling it this, the shitty first draft. Um, and it's hard for me to get to the point where I'm ready to start. And uh, this blog post by my friend Raul Pacheco Vega, who I've directed you to on other topics. This is a post of his about like basically how to go from the blank sheet of paper to a
Yeah.
first draft. And it's a little bit of a mental hack, right? It sort of like fools your brain by doing things in a way that don't necessarily call for that don't necessarily feel like writing, but then at the end you've got some significant text. So um, obviously, all of these are things that if they work for you, they work, and if they don't work for you, you don't have to feel bad that they don't. Okay. Um, but it is a tool that you can play with, and see how it helps.
Yeah.
So, how is everybody else doing?
Thanks, sir.
Sir, I just have one question in particular.
42.
I-
I'm being facetious. Go ahead.
Okay, so the exam on Monday, is it gonna be like a multiple choice or is it like a written essay type of thing? Like,
Okay, so uh, I feel like there were some emails that went out about this, but let me explain this one more time. The exam consists of 20 multiple choice questions and 20 short answer questions.
okay.
The short answer questions are optional. Okay. They all are the same thing. Explain why your answer to the previous question was correct. Okay. If you get the multiple choice question right, full marks. Good job. Let's move on. If you get it wrong, you can make up some or all of the marks by giving me a compelling explanation as to why your answer was correct.
Okay.
That's how the exam is set up. You have to answer the multiple choice questions. You get them all right, great job. We're all done. You get them wrong, I will go and look at the corresponding short answer question, and you may get some of those marks back.
Okay. Thank you.
Yeah, no problem. All right. Anything else? Anybody else? Go ahead.
Piggybacking on Mr. Patrick, how long would the short answers be? How long do we have to make it?
Very, very,
Very
short.
short.
Very short. Like I have to, when I insert a short answer question on e-learning into the exam, I have to give it a correct answer. Now, you are not going to, if you happen to match the answer that I gave it, you don't get any marks because it's explaining why the correct answer on the multiple choice question is correct. So you've already gotten your marks for getting the multiple choice question right. So if you happen to match what I said, great, congratulations. No additional marks are awarded. But my short answers, I think the longest one is like 5 words. This is not
Okay, 5 words.
5 words. So this is not something that is, that you should put a ton of time into.
Sir, so just for clarity, the short answer questions are optional. We don't have to do them.
That is correct. If
Okay.
you are confident in your answer to the multiple choice question, you are not required to answer the short answer. But the reason the short answers are there, frankly, is because the central administration would not approve a multiple choice midterm. They required that it be a short answer. So you get short answer questions. If you answer them and marks and there are marks for you to make up, you get them. But if every single one of you answers all 20 of the multiple choice questions correctly, I will not even look at anything you put on the short answer. So simple as that. Okay. Anybody else have questions or complaints about the exam or anything else?
And we're stopping at damages, right?
Through defenses, yes.
Oh, defenses, right? That's what I wanted to say.
When we started doing occupiers liability, that was the point where things were not going to appear on the midterm.
Okay, great.
Mhm.
So it's basically we're doing just negligence, duty of care. Right,
Yep.
great.
Yep, just negligence. Yep. Joshua, you're off mute. Did you have something?
Oh, I was gonna ask this. I was gonna say the same thing that she was saying.
Okay. Anything else, guys? No? Okay. So let's check in. So how do you guys feel about the occupier's liability stuff? Does that seem like it's making sense for you?
Yes.
Is that a yes?
Yes, sir.
Okay. Okay. Good. Anybody want to disagree with that? This is your space. This is a place where you can do that. No, we're all good. We're good to go. Okay.
I
I
would
haven't been able to give it as much attention as I would have liked because I'm trying to prepare for the midterm and
Mhm.
to do some other things. But I wouldn't say that I don't know exactly what's going on. I think it's pretty understandable so far.
Okay. That's good to hear. So, Colette, did you have something?
yes, I was going to ask the level of duty of care or for an occupier would have to a passerby. I'm noticing there's a construction near my workplace.
Well, your mic
No, it's not low.
your
It's
mic
not.
cut out right as you described. Yeah.
Hello,
So
hearing me now?
yes. So let's say that
Start
again,
over.
please.
Right.
Yes.
Um, I want to know the level of liability an occupier owes to a passerby. And this is what I've noticed. This is real life. There's a construction going on near my work, and the what you call it now, pavement is now occupied by these people, and they chose to throw like the pieces of board that they are have finished using onto the pavement, and sometimes it goes over into the road.
Mhm.
Now, if someone should unfortunately hurt themselves, granted they'll try to avoid it, but if it cannot be avoided and they try to pass, how how would that how would one deal with that?
Well, I guess the first question would be, um, is the pavement part of the premises?
No.
Right. So that's the very first question, because, you know, in a lot of places like where I'm from, the pavement, or the sidewalk as we call it, um, is actually part of the road in terms of where the property lines are. And so it is owned and controlled by the government,
Yes.
which introduces other problems that we're not going to get into, right? Issues with sovereign immunity and things like that. Not what we're going to discuss today. But and so that raises the issue of, are the construction workers who are, putting their waste on the pavement, are they actually trespassing by doing so? Or are they making use, like, does the premises extend all the way to the curb and therefore is under the control of the occupier? That's the first question. The second question that I would have is, what's the status of the passerby, right? Are they considered, and this sort of is I think linked up with who owns, who's the occupier. Because if the passerby is trespassing, then the answer is that the duty owed is the duty of common humanity, right? Very minimal. What I've been describing this whole time as like a duty not to watch the trespasser bleed out and die, right? But if the passerby is a licensee, right? So they have they have permission to pass through the premises by way of using the pavement, then that's a duty to warn of hidden dangers. So based on what you're telling me, I don't necessarily see a breach of the duty either way, assuming that the that the occupier controls the construction workers. I don't see a breach of the duty because if the passerby is a trespasser, then obviously no duty is owed. And if they're a licensee, well, these are sort of open and obvious things, right? The boards and the waste that is out there is just sort of visible for anybody. So there's not a hidden danger to warn against. So I'm listening to this and I don't necessarily see a breach of the duty. I don't see any liability for this particular occupier. So does that make sense to you, or do you, are there other things that maybe you want to push
I
back
think
with?
I think they should at least put up a sign with reference to the area that they might be they are trespassing on, because it is the road, it is the government pavement,
Mhm.
and they have no requisite signage to say men at work, or you understand, those little things.
Yeah.
Well, I'm living in Trinidad and I'm not seeing that. If I was living in Jamaica, definitely would have signage like that. That definitely
Yeah.
tells you.
Well, some of that I think is also because, Jamaica has
We do have an Occupiers Liability Act. Oh, you're frozen. Why? Hello?
I
here
think.
to make the property reasonably safe.
Sir,
It's
repeat what you said because you stopped there. You were stuck for
You
like a
froze.
good.
yeah. What I was saying was that, Trinidad is a common law jurisdiction on occupiers liability, whereas Jamaica has their occupiers liability statute. And if you remember, right, the statute imposes a single duty of care for all lawful visitors, reasonable care to keep the premises reasonably safe. And so in those circumstances, right, in Jamaica, you absolutely would see a men at work sign or a, beware of falling trash sign, because that would be part of the reasonable care and also part of the, you know, the disclaimer of liability, right? The ability of the occupier to warn visitors in order um, rather than having to take a positive action. But in Trinidad, you don't have any of that. You just have the common law. And so the folks who are using the pavement are at best licensees. They're not there to serve an economic purpose. They're there because they have permission to pass through. And so the duty in that case is to warn dangers, and there's nothing hidden. So now does it make more sense now?
Yes, thank you.
Good. Good. All right. So is there anything else before we move on? Okay.
Hey,
So
sir. Sorry.
yes, go ahead, Michael. Go ahead.
So similarly to Lynn, what she was saying, with regards to studying for this particular topic, it has been kind of thrown out by the preparing for midterms and stuff like that. But superficially speaking, occupiers liability seems to me like the law is like what we had discussed in class the last time, where we were talking about how the law is not necessarily is trying to make sure that people are accountable for, you know, things that they should be able to avoid, i.e. negligence, that kind of stuff. But my issue with regards to occupier's liability is this idea that the law is kind of overstepping um in certain instances, right? Like I feel like if it's nitpicking a bit, because from some of the things, and I can't remember exactly the cases and stuff like that, because I still have to go through it in depth. But from a superficial standpoint, it seems as if the law is nitpicking in certain areas, which concerns me a bit, although I understand the reasoning. I just am a little bit wary um of the extent to which the law goes with regards to certain things. Yes, I mean, that's just my little comment.
Well, I mean, I would agree with you that the distinction between licensees and invitees in particular seems like a very fine distinction for the difference in the duty of care, right? You know, like I said a minute ago, licensees are owed, you know, a duty to warn them of hidden dangers, whereas invitees are owed reasonable care to make the premises safe, right? And that's a massive difference. But the only difference as to which side of that line you fall on is whether you're there to do business with the occupier. And that strikes me as being a very fine distinction for a pretty massive change in what is expected of you. Um, so I agree with you that, you know, as a sort of as a prescriptive matter, this seems to be a little bit of straining at gnats. Um, the law can be like that sometimes. I'm not, I don't want to go down a rabbit hole too much, but like in, I'll tell this one war story and then we'll move on to sort of illustrate what I mean by the law does that sometimes. I was trying a case, and one of the issues in the case was whether the plaintiff was an employee of the defendant or an independent contractor. And the test of whether he's an employee is a 6-factor test where no one fact determines any one factor. And so the plaintiff's lawyer, I was representing the defendant, the plaintiff's lawyer shows up with a great big poster board. And the poster board is divided into 6 sections for each of the 6 factors. And every time he asks a question that establishes a fact that he thinks leads towards one of the factors, he puts a little Velcro sticky up on his poster board for the factor that it establishes. And he goes through this for the whole test, for the entire thing. And he had 25 different things that he had prepared that he was going to Velcro up. And he made the mistake of letting me have the exhibit when I cross-examined his client. And every time I got the client to admit that one of the facts didn't actually prove what he wanted it to prove, I took it off the board and threw it on the table in front of me. Here's the point of this story, right? This was a massive amount of effort to establish these teeny tiny little facts, right? These are facts like who paid for your gas when you drove around doing this job? Who paid for your laptop? You know, were you required to have a cell phone? Who paid for that? Right? These are the kinds of things that change the outcome of the case. And they're little tiny facts. And it's the same way with this kind of doctrinal difference. These little tiny facts completely change the outcome. And that's, whether we think that's a good thing or a bad thing, it is a thing right now, right?
My thing with that is, I think where I'm coming from with this sentiment is that because they're so small and oftentimes overlooked in a lot of instances, I feel like the facts could get blurred up. There could be situations where even the client could not even remember certain little things because they may see it as minute or whatever the case may be. And to base doctrines on something that is that small seems very ill-advised. I don't see how this kind of doctrine can really be sturdy in certain situations. It seems too shaky.
Well, I think that, the legislators in Jamaica and Barbados might agree with you, right? Which is why they enacted the statutes in question. But I think that one of the things that may be helpful to you is to think about, like, what do you think happens when a plaintiff can't remember the necessary details to establish a doctrine?
You're asking me?
Yeah.
Oh, I think that depending on the lawyer, they could like put words in their mouth.
Well, let's just say that, the plaintiff is a relatively competent witness and they don't testify to things they don't know, but their testimony is that they do not recall whether they were on the premises to conduct business or not.
I know the first thing that comes into my head is that it's overlooked and it's an assumption is made.
What assumption do you think would be made?
And that's that question, actually. I don't know.
I'm sorry?
I said I can't answer the question. I really don't know. I'm thinking that the assumption that goes into their favor would be made.
So I think there's a couple of different answers to this, right? One is that I think some judges would assume that if you don't recall evidence, that whether, the existence of a fact or not, that if you did recall, it would go against you, right? An adverse inference assumption. Other judges are going to sort of look at the broader circumstances. And so, like, if the premises is a grocery store, do people often go to grocery stores to, like, hang out and socialize? Is that a thing in the Caribbean? I don't know. It's not a thing for me.
I mean, if you see your friends at the grocery store, you would probably talk to them, but it's not like a hangout spot. They usually go to like village shops.
Right. And so the judge might infer from where you were, whether you were there, whether you were likely to be there to engage in business or not. Okay. And how that inference is drawn might depend on a number of different factors, right? That depend on just sort of the general cultural competence of the of the judge and of the parties and the lawyers, right? So this is, I understand where you're coming from. I don't disagree with you that these are small things that turn cases. But where I don't agree with you is there seems to be embedded in your comments this idea that it breaks down the system. Well, no, it doesn't. The system copes, right? The system manages. And that's sort of what that's the lesson that I would encourage you to take from this, is that, when we build these doctrines that feel unworkable, like, part of what the system does is learn how to work with it. And if it really is unworkable, throw it out. Right? That's a thing that happens too. Courts say, we tried this, it very clearly didn't work. we're going in a different direction, right? That's a thing that happens sometimes. So.
I understand. I get you. I guess in my mind, I'm just thinking the amount of, because it's so trial and error that, you know, obviously there will be quote unquote casualties before you get to a good place or whatever the case may be. And I think I'm taking that into account more so.
And unfortunately, this is not really a system that does that, right? The system sort of says that this, you know, our process and our solutions are what's important to us, and the lives and livelihoods of the people who, you know, get chewed up in the process, not really our problem. And I hope that you and all of you don't ever forget that there are real lives and livelihoods at stake in these, you know, debates about abstract doctrines. Right? That if you take nothing else from this class, that is the most important thing that you can take from it, is that every single one of these cases represents at least two people's lives. So, all right. On that note, let's move on to something more pleasant, which is remoteness. Okay. This is going to be very brief because we've been discussing other things, but that's fine. This is your tutorials are your time to cover the things that you guys need to feel confident with the course materials. So the prompt for today, for those of you who have not gone on e-learning, the prompt for today, there's a little more to it than this, but this is the key piece, okay? To write a fact pattern that in your mind would fail each of the three questions in the remoteness analysis. So we are short on time, so we're not going to do the full think, pair, share. Is there anyone who had a chance to work on this before the beginning of the tutorial that would like to share what they came up with? Okay, let me ask the question a little bit differently. Is there anybody who had a chance to look at this before the start of the tutorial? Colette, okay, yes, okay. So let's hear from some of you guys who said that yes, you did. If I need to call on someone, I will, but I would prefer volunteers. I always prefer volunteers. So if there's someone who would be willing to go ahead.
I'm not so sure if mine is correct. It's a fact pattern, right? A candle was lit in a home for religious purposes, right? It was placed near a window curtain and near the window. There was no wind, but however, a strong wind blew the curtain and it got lit by the candle. The candle, it started burning. No, a fire lint blew to the neighbor's house. And the neighbor was not at home, but they usually leave their top floor window open, and this lint lit the curtain and their house was devastated.
Whew. So I assume that we have a claim from the neighbor against the property owner.
Yes.
Okay. So what is the instrument of harm?
Maybe
The fire, the lint, the candle.
So I'm hearing a couple of different answers, and I think that this is a really helpful. I think that's a really This is a really helpful point, right? Is that you can characterize a couple of different things as the instrument of harm, right? Let's say that you are the plaintiff's counsel, okay? So you want to pass the remoteness analysis. How would you characterize the instrument of harm?
Anything that was related to the fire.
Right. Fire, candle, right? Those are going to be your instruments of harm. Why? Because if those are the instruments of harm, then those are reasonably foreseeable sources of danger. If you're the defendant's counsel, how are you going to argue, what are you going to call the instrument of harm?
The wind.
Oh yeah, I was just
Maybe
gonna say
maybe the wind, maybe the curtain lint.
Curtain lint, yes.
Yeah, right. So things that we kind of look at and go, oh, come on, that's not really dangerous, right? Because you want to fail that first step of the remoteness test. Now, which of these do you think is more convincing as a descriptor of the instrument of harm?
I would say the wind.
I think that's, yeah, okay.
I would say that because it is like you cannot really. Actually, no. Probably the fire is more convincing because of the devastating nature of a fire. But I mean, as a defendant, if you say the wind, you could probably cancel out the fire because what's the probability that the the way it's called it would blow into the thing upstairs.
Right, and I think that is. I think you're right that that's probably the strongest argument for the defendant, is to argue that the wind is the instrument of harm rather than trying to argue that it's the curtain lint itself. But I think that you guys are right in sort of tracking down that there's room for disagreement here. We don't have a clear failure at the first step, but certainly we have an argument that could be made. And that's very good, right? Because the first step is actually very easy to clear, right? So if you guys remember, if you looked at Professor Dworkin's article that's posted to e-learning along with this tutorial question, you would note that he makes the point that this first question is very easy to answer in the plaintiff's favor. It's very rare for something to not be a reasonably foreseeable source of danger. So coming up with a plausible argument on that first step, I would say, is a win, is an accomplishment. What about the manner of harm? Does the story that we've told, does it pass the daftness test?
You mean the fact that the candle was lit near the window?
Yep, and the whole kit and caboodle, right? Wind gusts in, ignites the curtain lint blows to the neighbor's house, etc., etc., etc. Does this seem like a daft story? Go ahead, Sasha, and you came off mute for just a second, and then you go ahead.
I was saying that it doesn't sound to me like it was reasonably foreseeable that would happen.
Why not?
And if I remember the facts well, maybe I would like her to repeat it, but did she say that the curtain blew up, the curtain became detached and blew up the window?
No.
No?
The thing is that there was no wind, but there was unfortunately, there was a gust of wind that caused the curtain to blow up and to catch the candle. The candle caught the curtain on fire, and that is where the fire started.
So I thought you said the curtain blew over to the neighbor's house.
No, the lint.
Oh, the lint. Oh. Okay.
I think you're absolutely right that if it was the curtain itself, we'd sort of be looking at that and going, maybe not. But with the lint in mind, do we think that was a reasonably foreseeable manner of harm?
Not really, considering that there was no, well, I have 2 points. One, like, how often does the lint from a curtain cause a fire?
Mhm.
And two, if there was no wind in the first instance and then there was just a sudden gust of wind, I think that if there was wind, they probably would not have put the candle so close to the curtain in the first place.
Okay, so I want to make one point, sort of leaping off of Michael's point, that I think is really helpful. One of the things that's really important in these remoteness analyses is remembering that the cases are very fact specific. And so if by some odd coincidence you happen to find a case that is, perfectly on point with your facts, the outcome in that case is almost certainly going to be the outcome in yours. But you will almost never find a case that is that perfectly on point. Okay, so if it happens once in the first 10 years of your practice, that would be a surprising number of times. Excuse me. Okay, but I think that you guys are grasping, right, that this is a go ahead, Colleen. Go ahead.
Sir, I was just wondering that there was an accident some time ago with the death of a young guy, a gentleman,
Mhm.
at our what cement plant. Would that be death due to remoteness too? Would that be a form of?
I'm not sure. I would need to know more about the situation before I would be willing to opine. Like he fell into a
Yes,
vat
I
of
think
cement.
something exploded. So I was here thinking if that would be the fault of the company that happened, or it was just.
Yeah, maybe. Again, right, I would need more information, but it seems to me that um an explosion is absolutely going to be a foreseeable source of danger. Um, Someone getting killed by said explosion, certainly a foreseeable manner of harm. And that brings us to the third question, right? Is the type of harm reasonably foreseeable? And this one is, relatively straightforward. Remember that the broad way of thinking about this just asks about the headings of damage, right? Damage to person, damage to property, economic loss. So do we think that the type of damage that was done was a reasonably foreseeable type of damage?
Say yes.
Okay, why yes?
Well, it was caused by fire. If you light a candle, there's always the possibility that a fire can happen if wind can blow down the candle. If you light a candle near to a curtain, in close proximity to the curtain, there's always the possibility.
You're overthinking. It's much simpler.
Sorry.
Do fires damage property?
Yes.
Yes. Did
That's
we have property damage in this case?
Yes.
There you have it. It is really that simple.
Oh. Okay.
It is. It's very easy to feel like you have to overthink things in law, and sometimes it really is just that simple.
Sir, I honestly think I suffer with that. I really do.
I think an awful lot of you suffer at that. I suffered at that at this stage of my career, right? It took me years to reach the point where I trusted myself when I had a simple answer. So don't don't feel bad. It's not uncommon. I'm gonna keep telling you, you're overthinking. It's not that hard. And eventually you will learn to trust that instinct when it speaks. Okay. So Colette, I really appreciate you letting us sort of work through your fact pattern. We are almost out of time, so let me pause here and just ask, what questions do you guys have about this? Go ahead, Lynn.
Well, I actually had a fact pattern that I wanted to share quickly.
Okay. Tell you what, because I have said this to lots of other students. Why don't you email me the fact pattern and I will shoot you back some feedback on it, rather than taking away other people's opportunities to ask questions.
Sure, no
Does
problem.
that work? Okay.
Yeah, that's
You're
fine.
more than welcome to email it, and that goes for all of you. I'm happy to review your work. Just drop me a line and I will send it along. Okay. So what questions does anyone else have? Okay. Well, if there's no questions, then Lynn, you can go ahead and lay it out there if you'd like. But that's up to you.
Well, it's actually quite simple.
Okay.
I'm thinking that George was in his yard and he was building something. And what he was building seemed outrageous to his neighbor. So his neighbor came over to say, "But why are you doing this?" And to argue because he was probably going over the line, the boundary line a little bit. And whilst the neighbor was there arguing, then a part of a plane dropped out of the sky and struck him. But and so
The good old Donnie Darko. Go on.
I was wondering, but that would be more a case of recipsa and not necessarily of the neighbor being liable. But I was still saying it could be something where it's remote because it doesn't seem like something that would be reasonably foreseeable. Just help me with my thoughts a little bit.
So then the plane dropped and hit who, the neighbor?
Yes.
Part of the plane?
He went over to the neighbor's house to argue, and while he was there, he got struck. He got hurt.
Like part of a plane that was passing by.
Yeah.
And your question is whether who are we supposed to give?
Who'll be
Huh?
liable?
Yeah.
I'm confused.
So my first question is who's the defendant and what claim is being pressed?
The person who got hurt is going to make a claim.
Against whom?
Well, I was saying it will have to be against the person who dropped the plane.
So the airline.
Yes.
Right. Okay. So what's the instrument of harm?
The object that fell out of the sky.
Is things falling out of the sky a reasonable source of reasonably foreseeable source of danger?
No,
I mean,
I
some
don't
of
think
that
so,
depends on
unless
how
you're,
big it is, right? But let's say that it's the Donnie Darko and it's an engine.
Yeah.
Is a plane engine falling out of the sky a reasonably foreseeable source of danger?
Well, if it falls out of the sky, yes, it will be
Yeah,
dangerous.
if it hits you, it's gonna hurt you, right?
Yeah.
Is the manner of harm reasonably foreseeable? Well, maybe not, right? Maybe the story that's here is a little wonky. There's weird stuff going on here. But like the notion that a heavy object getting dropped on you is going to hurt you, probably
It's
reasonably
normal.
foreseeable. Yeah, that seems relatively normal to me. Is the type of harm reasonably foreseeable? So if something heavy drops on you, what kind of damage does that do?
Some sort of damage to the physical body.
Right. Yeah. Damage to the person. Right.
Yeah.
And is that the damage that was experienced?
Yes.
Yeah. So like this is one of those things where it's a really creative fact pattern that absolutely is amenable to sort of the regular analysis. Right.
Right. Okay.
So I have another meeting, so I can't stay to talk through this in great detail, but here is when I was asked for a fact pattern, here's what I came up with, right? Penelope Plaintiff is at a tea party where she is served a cucumber sandwich, which she eats. The cucumber sandwich, a seed from the cucumber lodges in her esophagus and sprouts and grows a cucumber plant in her esophagus. She goes to visit a treating physician who is baffled by what is going on, does not perform the appropriate tests to determine, and she dies. And her estate, but when she dies, the power at her house is cut off. Because the power at her house is cut off, her computer turns itself off. And her computer had been running a Bitcoin mining operation. And had she survived, she would have mined a new Bitcoin. And so her estate sues the treating physician for the loss of the value of the Bitcoin. So, is a cucumber seed a reasonably foreseeable source of danger? No. Is this story a reasonably foreseeable manner of harm? Not really, right? There's an awful lot of places where this story smells like an idiot ball. Is the type of harm reasonably foreseeable? No, because it's an economic loss. And we have the case where we said that medical malpractice doesn't foreseeably lead to economic loss. Okay? So do you see now like how bizarre, like how this is a boundary drawing exercise and how bizarre this has to be to sort of get outside of the remoteness analysis?
Yes.
Great.
Definitely.
Outstanding. All right. Well, then I'm going to let you guys go, and I'm off to my next meeting. But thanks so much, guys, and I will see you next week. Have a great weekend. Take care, and bye.